to make a short opening statement, and you can begin by stating your full name and the capacities in which you appear, and of course introducing your colleague as well. Thank you.
Thank you very much, Senator. My name's Kate Carnell, the Australian Small Business and Family Enterprise Ombudsman, and with me is Alexandra Horden, who heads up our advocacy and policy area of the organisation.
Thank you.
I'll only make a really short statement because I think we've put in some submissions and I won't restate those, but I think it's really important when we look at this whole situation with dealers and manufacturers in the motor vehicle space. The first thing we've got to understand is that there is a huge power imbalance. Even when the businesses are, shall we say, bigger than would normally be regarded as small businesses. It's true that, you know, in things like the unfair contract terms space, very few dealers would turn over less than $10 million per annum, and fundamentally because, as we understand it from the industry, their margin is less than 1%. So you've simply got to be bigger than that to be trading at all. Many of these businesses, as we know, as I think we all know, are multi-generational. Their investment in their business is millions of dollars. Much of that investment has been enforced by the manufacturers over time. So the great dilemma here is that these businesses have very little choice but to comply with whatever the manufacturers require or want. And interestingly, we've been told by the industry that since Holden left Australia and did it the way they did, a range of incredibly unfair contract terms have been actually added to the contracts because, well, you could argue Holden got away with it, so, you know, we can too. So I think there's a range of things that have happened that are good, such as the amendment to the franchising agreement for the motor industry. There's a range of those requirements which are a really big step in the right direction. But I'd have to say, moving to a scenario like, you know, you've got to have 12 months' notice before you have your contract terminated, but without necessarily any compensation in the space. If you're a multi-generational business with millions and millions of dollars investing, 12 months isn't very long, especially with no compensation necessarily in the space. So I think when we deal with this industry particularly, we have a bigger imbalance of power and some larger problems than we do in a situation where there is more, shall we say, competition in the marketplace. Alexandra, do you have anything you'd like to add to that?
That covers it. Thanks, Kate.
Great. Thank you.
Senator O'Neill, would you like to kick us off? Oh, she's still returning. I certainly had questions, or Senator McGrath. No, I hadn't realised. Thank you.
Thanks, Chair. Sorry, I just needed to attend to a matter then, and I missed a little bit of your introductory remarks. Sorry if I go over any territory.
No,
apologies. And if you need to restate, I'm sorry.
Sorry.
So, one of the key things that has been described by the industry, which employs 56,000 Australians and also has thousands of apprentices and is widely distributed across the country, is that despite their size, and people see these businesses as they drive past, they're actually small players by comparison to the international companies that manufacture the vehicles and ship them to Australia. Is that a fair representation of how power is operating in this sector?
Absolutely. As I said in my introduction, that if there's ever a situation with an absolutely dramatic power imbalance, it's this one. If you're a Mercedes dealer and it's a multi-generational approach often, Dad had it, Granddad had it. We've invested millions and millions of dollars in our operation. You can only deal with one company, Mercedes, so you haven't got another choice. So all of the power sits with the manufacturers, and I suppose the challenge for all of us is to have some form of, is to have in place approaches to balance that up just a little bit. We'll never make it totally balanced, but we've got to do better than we have so far. I made the point that the changes to the franchising agreement from the 1st of June are a step in the right direction, but it certainly doesn't solve the problem.
And we've certainly got the reality of General Motors moving off. We've had companies fold, including one in Dubbo. If I can just go to that one, you might be able to sort of give a response in the particular here. There was Mr. Michael Adams, who owned the Golden West automotive dealership in Dubbo, which is in the federal seat of Parkes, great big middle of New South Wales hub, really important for the whole of Western New South Wales as a provider of health, access to services, mental health services, business services. It's very significant. But according to, are you aware of Mr. Adams? Have you heard anything of his case?
I mean, apart from having read a little, but no, we haven't dealt with him as a case.
But his case is that, reported on the 15th of September this year, that due to the sudden withdrawal of General Motors in the Australian market and Honda changing their business model arbitrarily, he had to close his business and he had to let go of 40 employees. You'd be aware of the voluntary principles that have been disseminated by the Secretariat during the course of this inquiry. What's your view about those principles? Would they offer more protection to Mr. Adams if they were mandatory and prevent what happened to him and the loss of those 40 jobs in Dubbo?
It is our experience that voluntary approaches don't work when there is a significant imbalance of power.
Why is that, Ms Carnell?
Because our experience is in this space that the large operators or the people with the power choose not to, shall we say, play or not to comply if it doesn't suit their business requirements, and they simply won't comply unless it's mandatory. In fact, we get told that regularly by multinationals that, if it's not legislation, decisions will be taken in the head office in the US, Europe or whatever. That's what they tell us.
I think if I might just be able to add, that's actually the key, is that with the multinationals, they don't have local impact on their business. So if they're making a decision in Delaware or wherever it may happen to be, they make a decision based on business needs rather than local needs and local outcomes.
So care and concern for Australian businesses and all the jobs isn't top of mind in, Europe or in the US or in any Asian country that might be providing vehicles into the Australian market.
That would be our experience, yes.
In unison, it's a chorus of accord with that reality. Are you aware of comments from Ms Seeger with regard to Mercedes-Benz? Have you heard anything of her comments?
No.
So to paraphrase, and I think I'm getting it pretty right, that she basically said that they would deliver their model into countries where the laws allowed it. The model is a change from this dealership model that we've got to a distribution model. Is that how it works? From overseas, people look at it and they go, well, hey, if I can get away with it in Australia, and they're not going to do anything about it. Let's do what we want. Is that really what's going on?
Senator, that is what we're told. As I made the comment earlier, we've been told that since Holden left Australia, that there have been changes to current contracts, putting in significant unfair contract terms into current contracts because they think they can get away with it. I think that's a really concerning situation.
Okay, so we just heard evidence from the Department of Industry, Science, Energy, Resource and Treasury, who do very hard work on behalf of the Australian people, and they've tried to provide reassurance that unfair contract terms are under reconstruction and that there's going to be a benefit from these changes from the government. We don't know when that legislation is going to come, sometime next year, maybe. Drafting hasn't even commenced. I think we've confirmed that this afternoon. So what protections against unfair contract terms currently exist for these big employing businesses across Australia in the car sector?
Senator, they're currently very limited. Given the caps on unfair contract term protections, there's very limited, if any, protection from unfair contract terms for these
So can you
businesses.
talk to that issue, the caps? What exactly does that mean? So if somebody's just listening to this inquiry and they're never had anything to do with the car industry, what does all that mean?
So the caps currently, before a contract can be subject to the unfair contract terms regime, come in at, I'm pretty sure it's $300,000 for the value of the contract. So if the contract is larger than that value, the unfair contract terms regime does not apply. The changes that have been agreed to at the Consumer Affairs Forum, as we understand them, will take those caps to $10 million for the value of the contract, or 100 employees for the business.
So just to make that right, there's two caps. One is what constitutes a business that's covered. Under 20 employees is the current scenario. What's planned is turnover under $10 million or 100 employees, although there's no indication at this stage is how you determine an employee. Is it just someone on the books? Is it FTEs? Is it something else? The good bit about what's being proposed is that it removes the cap on the value of the contract totally, which is great. We think the changes proposed are really, really great. At the moment, the cap is on the contract is $300,000, as Alexandra said, for a single-year contract, or $1 million for a multi-year contract. So the current unfair contract term legislation doesn't cover these guys at all. They're too big for this. The proposed changes for next year, turnover, none of them will turn over under 10 million. With margins of 1%, they'd be out the door pretty quickly if that's where they were. The issue around under 100 employees will depend greatly on how that is defined in the Act in the future, which we have no idea about. So I think it'll be important for the changes to unfair contract terms to make it 100 FTEs at the very least. Even then, some of these businesses, we are told by MTAA and others, will be bigger than this. Remember, they've got repair sections, they've got vehicle sales sections. They've got lots of people, which is the reason they've got so many employees in Australia.
Exactly. And I, for one, don't want to see those jobs disappear, because it's hard for me not to think about what it means for a young person sitting in the back row of my Year 9 class, and the only thing that they want to do is go to the local car dealer and become a mechanic or a technician of some sort, or an electrician, or work with the cars, detailing. I had one kid who just the reward for great behaviour was actually washing one of the teacher's cars was a big reward. For some kids, this is their life star, their lodestar that they want at these jobs. Once they're gone, they're not going to come back.
Just a good news story. The Western Sydney Woman of the Year this year was a 23-year-old apprentice that does spray painting fundamentally which is just a great news story.
Yes. And would be happening all the time as cars are turned in and getting fixed for resale. In terms of the numbers, I'm just mindful that Honda have told us today that they're getting rid of participants. They're shrinking the number of owners that they have. They said that they were going to keep close to their current level of sites, but reducing the number of owners. If that's the case, they would be more likely to hit the 100 employees if they're large businesses, and therefore would not be able to avail themselves of the unfair contract provisions that are yet to be implemented but proposed.
That would be right. I think there'd be a range of, well, we know there's a range of businesses now that are in that situation, because even if a dealer they might have a number of brands, we've seen them down a road. There's a company that sits over the top. So you might find that they get excluded fairly quickly. But it's something that's got to be taken into account when we look at what the amendments to unfair contract terms look like. And of course, if it's not FTEs, then lots of dealers will go, they'll have more than 100 people on their books.
Yes, of course. In terms of the unfair contract terms, could you put on the record some of the examples of ones that you're aware of that are now being implemented in this vacuum of where the government hasn't actually resolved this problem?
So I don't have any examples with me, but we can certainly take that on notice. I would say, though, it's uncommon for us to see a contract that does not include an unfair contract term in there.
Sorry, could you just repeat what you said?
Yeah. It's uncommon for us to see a contract that doesn't have an unfair contract term of some sort, whether that's a unilateral variation clause or something else. We usually will find an unfair contract term in most contracts we see.
So that's a very concerning reality for businesses right across this country. How can it be that contracts can have unfair contract terms in them? How does it come about? And how do you interact with that?
So, the contracts are usually created from precedents, and so often these contract terms which had previously been acceptable practice, they sneak in and they continue to be used in contracts as they get rolled out. They get changed as people complain about them. One of the issues that we've raised with the current unfair contract terms regime is that in order to get one of those terms overturned, usually the small business, would need to take the other party to court to have that contract term overturned. So there's quite a process to go through to get out of these unfair contract terms. So that's usually how that happens.
So unless you've got a lot of money, basically you have to accept the contract that you're given by the big entity that you are seeking to do business with.
Most large entities will say that their contracts are negotiable, and to a certain extent they may be, but ultimately, as Kate's pointed to, if you've got a multi-generational business that you've put a lot of money into, you're unlikely to walk away from a contract over an individual term unless it's outrageous.
I do recall in the inquiry into franchising that we had evidence that said that there was very little room for anybody to take action because unconscionable contract terms were just everywhere throughout these documents that franchisees were signing, despite the fact they were getting legal advice. So getting legal advice wasn't preventing them from signing terms with unilateral, what did you just say?
Variation clauses.
Now, what does that mean, Ms Horton?
So that's where one party can vary the contract at any point where they choose to vary it in a way that they choose to vary it.
So essentially that means sign this document with all this language and words in it, but it doesn't mean anything because there's one clause in there that says I can do whatever I want anyway. Is that it?
Yes, ultimately.
That's pretty dodgy, isn't it?
Yep. And then there's the clauses that say we can require you to upgrade your premises at any time to a standard that suits us, not you. We can require you to take any number of cars without you having any input into that. And remember, franchisees buy the cars. We can change our sales requirements at any time without, without your agreement. They're pretty great contracts.
Whole agreement clauses where they say nothing we've said to you prior to you signing this document has any bearing on the contract, so they can make as many promises as they'd like before signing, and if it's not included in the document, it doesn't count. So, yeah.
I think we saw with Holden, didn't we, that, you know, a lot of companies were told things that turned out not to be true. You know, that they were not given any indication that Holden were pulling out, even when they told Holden that they were planning to purchase a new, you know, an existing franchise or do a merger or, you know, go down the path of quite significant expenditure, literally months before Holden left. So we saw that there was no requirement for transparency or reasonable information provision or sharing. And that's, you know, that's pretty normal in this space.
It might be normalised practice, but it's profoundly unethical from, I think, the general pub test. It wouldn't pass it, would it? Because it's exploitative. It's not business, it's exploitation.
It's significant offshore entities using significant power to the detriment of Australian businesses. And I think your comment about unconscionable conduct, Rod Sims from the ACCC made comments about that, and totally appropriate ones just recently, to say the problem with unconscionable conduct is trying to prove that in a court of law is almost impossible, so that we don't have solid laws against unreasonable, unfair, unethical behaviour. Just don't. And I think that was the point Mr Sims was making, that we had a bit of a gap in consumer law.
Do you have any sense of how many may or may not be covered in the car dealers' business by the proposed changes of 100 employees, whether it's FTE or something else, or 10 million? Is there any research to inform those arbitrary determinations that would be good for this industry?
No, we don't. The organisations representing the industry tell us that the 10 million, everyone will fall outside that, or almost everybody of the new car dealers. The issue with 100 is just how that is legislated, and as you said earlier, just what the manufacturers are doing in terms of consolidation of size of distributors. So it needs to be kept in mind heavily. As the department rightly said, unfair contract terms is across the economy legislation. It's not made for this purpose, and yet we really need to ensure that unfair contract terms do apply to these sorts of franchising agreements.
And that's perhaps why there was a call for a standalone franchise code for this industry, given its size and scale and reach and impact. And it appears it was promised in the MyEFO of 2018-19, but has not yet materialised and doesn't look like it's going to materialise.
It's our understanding that the 1st of June changes, that morphed into the 1st of June changes, with the changes to unfair contract terms separate.
So I would call that a broken promise. You don't have to, Ms Carnell. When there's been a dispute in the franchising sector, could you just recall an instance where you've questioned if parties have lacked good faith when mediating?
Look, because we are not party to mediations, you know, the mediations happen between the mediator and the parties involved, but we get feedback, and Alexandra might like to talk about AMP, sort of.
AMP, Senator, which you're familiar with.
Yes.
We've had some feedback about whether or not that mediation has been entered into in ultimate good faith. Certainly we always explain to the parties the need to enter into mediation in good faith to get a solid outcome. Occasionally, when outcomes don't go the way that one party feels that it should have, they may not feel that the other party's acted in good faith, but certainly AMP is one where we've had have had reports of a perception of one party not acting in good faith.
General public might call it sort of a stonewalling situation, where you're told to go into a room and sort it out, and somebody just sits there with their arms crossed and basically keeps shaking their head.
And look, we get those. Well, we get feedback that's what's happened when they're And the hard bit here again is you get to a mediation scenario, you've got all the power on one side. If those large entities they'll turn up at mediation because they have to, but that's all they have to do. There doesn't have to be an outcome, which I think is the reason that the industry in the motor vehicle space wants an arbitration. Wants arbitration or compulsory, well, it ends up not, it can't have compulsory arbitration, but arbitration to be part of the whole approach here, because where there's serious power imbalance, it's just too easy for one party to turn up and stonewall, as you rightly say, and we do see that happen. We see some great outcomes where people are, doing the right thing, but that isn't always the case.
So we've heard about impediments to arbitration, but it would seem that if there is a code that you were required to sign onto, and in that code there was a term that said you agreed to binding arbitration, then that would change the dynamics quite significantly for this industry. Is that how this problem is resolved, Ms. Carnell?
We would support that approach. It then ends up being voluntary because you sign and you're voluntarily signing, but part of that is that you are willing to be part of an arbitrated outcome. I think it's probably essential in this case.
So the voluntary part is Mercedes-Benz, Mitsubishi or Honda choose to come and do business in Australia. And when they get here, the government says, welcome, but we're going to stand up for our small businesses. If you want to do business in our country, you need to sign into this code, and in the code is a statement that says, if things go badly and we end up in a business divorce situation, you will have to go to mandatory arbitration if you cannot resolve it in any other way. Would such a structure be within the constitutional bounds, and would it deliver the outcomes that the AADA and the MTAA are asking for on behalf of those 56,000 employees in the motor trading industry?
We believe so. The Dairy Code has arbitration in it, so does the Food and Grocery Code.
And it's by that mechanism, so it's, if you want to do business, you need to sign on to the code, and arbitration is part of participating in business through that code.
Yes.
So, Senator, just with the Dairy Code, the way that it's set up is that it's a mandatory code. You have to, provided you fall into the requirements, you have to be bound by the code. As part of that code, you must have either mediation or arbitration or both in your contracts as a way to resolve a dispute. So they don't enforce arbitration on the businesses, but you have to have at least one, if not both, in your contract, so that when a dispute happens down the track, you've got those clauses to draw on.
Mm-hmm. Okay, so there's a little bit of wriggle room in there, which could work when everybody's happy at the beginning of the relationship. I'm always concerned about when it comes asunder, what actually happens then, where the power lies, because we've seen terrible outcomes. All of the dealers who've participated in this inquiry have asked for binding arbitration through the sort of mechanism we've just been discussing, to ensure that resolving the resolution of disputes is possible. Do you believe that if binding arbitration was delivered in the way it has been through that mechanism in the Dairy Code and the Food and Grocery Code, and it was implemented for the car dealer network industry, then we would see a decrease in disputes in the courts?
Yes. We do.
Right. So can you give us, from your experience, what's happened with the change in the other codes? What's happened in terms of court matters and the decline in those matters coming to court?
Well, the whole point, a lot of these things never get to court because that's the point of power imbalance. The little guys can't take on the big guys in court, or they'll be worse off than they started. So these things rarely get to court. But what happens is they also rarely settle. under normal circumstances because the big guy's got all the power. When you put in place these sort of, a stick, which is what arbitration is, that if all else fails, we'll make the decision, or an arbiter will, then all of a sudden there's a reason to settle. There's a reason to not push this through to the final scenario. So I think it's not about court, it's really about pressure to actually behave in a reasonable manner, because if you don't, there's a stick.
Is it safe to say that if binding arbitration were to be implemented in the way that we have just been discussing, given the recipe that's been made available, interestingly from the food and grocery industry, if it was implemented, it would go some significant way perhaps, to addressing the power imbalance that we've been talking about this afternoon?
But we believe so.
Yep.
Yes. It's interesting in the food and grocery space particularly, the arbitration power, I understand, is almost never used because you don't need it anymore, because there's pressure to come to the party to get an agreement.
And what would it take to replicate that? Is it simply a matter of the will of the government to lead on this and bring in the necessary reform?
Look, I'm not going to try to be a lawyer here. It is certainly our view that arbitration is an essential part of access to justice, particularly in the SME space, but more broadly in this space as well. So I think the issue is how you do it. It's got to be constitutional. We've got to be able to deliver on that. But without arbitration, I don't believe you'll really deliver appropriate access to justice, access to reasonable outcomes.
So access to reasonable outcomes in this form, if it was instituted, clearly you're indicating there would be a change. If there was a massive failure in that, or people felt that it was breaking down, there is still always the opportunity for a business, if sufficiently cashed up, to take action in a court. This would not preclude court action. No. This is just a way to try and make sure that businesses play nice, that power is mediated in the public interest to maintain a sector and jobs and the viability of those businesses.
Yep.
So what do you say to the argument that, look, there's been enough change? This thing got changed in 2015, it's got changed again now, we've got to wait for it all to wash through. We don't need any more red tape. What's the response to that argument, Ms Carnell, from a small business point of view?
We believe really strongly that where there is significant power imbalance, that it is the role of government to put in place mechanisms that will achieve a more level playing field. And as I said right at the beginning, in this particular industry, the playing field is not level at all.
And apart from the quintessential unfairness of that, and Australians do care about fairness, why should businesses be given that support? Why should the government intervene? Like, what happens? Like, what's the worst thing that's going to happen if they don't intervene? A few businesses go under. Shouldn't the government just keep their nose out of business and let business do its own thing? Isn't that the argument all the time?
We don't subscribe to that view. We think that the role of government, is to ensure that there is a fair and reasonable playing ground, shall we say, that small to medium businesses, or businesses generally, have the support that they and legislation that is needed to balance up the huge power of multinationals and small to medium businesses. Without that, large businesses, particularly multinationals, who, as we said before, decisions are made elsewhere in the world, are going to operate in their best interest, not the best interest of Australia or businesses here in this country.
I think you might be very interested in the evidence we received earlier in the day from Mr. David Blackall, who basically said 56,000 Australians are waiting for the government to make sure that no international business, multinational corporate, can, with a stroke of a pen or the push of a button in far-off places, disrupt or destroy Australian business.
Seems a reasonable statement.
I thought it was, that's not, I'm paraphrasing him slightly, but that was pretty much it. Okay. Thank you very much, Chair. Thank you for the
Thanks
witnesses.
very much.
Thank you, Senator O'Neill. I just had one question for you, Ms Carnell, which was to ask, in the context of compulsory arbitration, if a company like Holden wants to leave Australia, and I know there's probably not a perfect solution, but how binding do you think binding arbitration would be?
A damn sight better than what we've got at the moment. Look, I mean, at the end of the day, the experience we have with multinationals, and this is in things like payment times, a whole range of things, they all say they will comply and abide with the law in the country that they operate in. They don't indicate that they won't operate inside Australian law. They won't just head off overseas and pay no attention. The problem is when you don't have any laws or requirements.
Thank you. Unfortunately, we've run out of time, so we'll see you again very soon, I'm sure.
Thanks.
Thank you.
Thank you.
Thank you.